Welcome to this Refugee Law Initiative conference panel session on non-signatory states and the 1951 Refugee Convention, snapshots from the Middle East and South Asia. My name is Maja Janmyr, and I am a professor of international migration law at the University of Oslo. I'm also principal investigator on the Beyond project that focuses on international refugee law beyond states parties to the 1951 Convention. This Beyond panel session seeks to examine important issues related to the linkages between non-signatory states and the Convention. At the end of 2020, 149 states were party to the Convention, its 1967 protocol, or both. And this, of course, means that 44 members of the United Nations are not party to any of these core instruments. And the reasons for not being party to the Convention or its protocol are varied. But of course, the fact of not being a party affects, for example, the legal requirement upon that state to comply with international humanitarian standards. So the papers in this panel thus address questions such as, what are the reasons for states refusing to sign or ratify the 1951 Convention? What influence does a convention have on non-signatory states? How do non-signatory states engage with and help shape developments within international refugee law? Full details of the 4 papers and presenters can be found in your conference program. And our speakers today will start us off by presenting key perspectives from the contexts of Bangladesh, India, Saudi Arabia, Kuwait, and the United Arab Emirates. And after this, we are lucky to have Professor Dallal Stevens from Warwick University, who will offer some prepared comments before we open up for a broader discussion and for questions and comments from other participants. And each of the speakers on the panel will have 10 minutes for their presentation, which I've been asked to enforce strictly. And during the session, please pose your own questions and comments to the speakers by typing them into the chat box here on Zoom. After speakers have finished their presentations, there will be time for them to discuss and reflect on your questions and comments. And please remember to keep your microphones on mute and your videos off unless you are a presenter. So this also means that this goes for the whole panel that we have here as well. Unless you present, please keep your video and microphone off. And this session is being recorded and will be posted on the RLI website as a podcast. If you do not wish to appear in the podcast, then please leave the session now. Also, if you wish to hide the live transcript at the bottom of your screen, please click the Hide Subtitles button. We now turn to our first speaker, Dr. Sanjeeb Hossain of the University of Oslo, who will be presenting a paper on Bangladesh's judicial encounter with the 1951 Refugee Convention. The floor is yours, Sanjeeb.
Thank you, Maja. I'm really happy to be here. As part of the EU-funded SLA project, I've been studying about the Rohingya refugee situation. And in the course of my research, I came across 2 stories. And what I'm going to do today is, without a PowerPoint presentation, I'm going to tell you those 2 stories. So the first story is about a Rohingya refugee called Muhammad Rafiq. And the other story, the second story, is about the 1951 Refugee Convention and the rather strange space it occupies in Bangladesh, a country that is hosting about 1 million Rohingya refugees since 2017. And the reason why I want to tell you these 2 stories is because they're kind of intertwined with each other. So let's begin with the first story, the story about Muhammad Rafiq. So I'm going to take you back to 2007, when Rafiq and his friend Hossain, they were basically stopped by the police in Chittagong, Bangladesh. And when they were asked about their identities, Rafiq and Hossain, they told the police that, hey, we're citizens of Myanmar. But of course, they weren't really able to sort of provide travel documentation. And they admitted that they had illegally entered Bangladesh. So in response to this, the police did what they're bound by law to do. They set in motion the provisions of a law called the Foreigners Act, of 1946. And under this law, they basically detained Rafiq, they detained Hossain, and legal proceedings were sort of initiated against them. And when formal charges were framed, Rafiq actually pleaded guilty. And as a result of that, he was sentenced to 5 years in prison under a particular section, Section 14 of the Foreigners Act. And the judge in that particular case, the magistrate who handed down that sentence, he further directed the jail authorities to push Rafiq back to Myanmar after he had served out his sentence. So, among the many tragedies of Rafiq's life, one particular tragedy is that Rafiq actually ended up in prison for the next 10 years. So essentially, he served his 5-year sentence, and then he remained in prison for another 5 years. So it was only in 2016 that there's this Bangladeshi organization called the Refugee and Migratory Movements Research Unit, which filed a petition before the Supreme Court of Bangladesh, asking the state why Rafiq, who had essentially completed his 5-year sentence, was still languishing in prison. And this is where the second part of my story begins. And the second story, it obviously relates to the 1951 Refugee Convention. And what I feel is this strange sort of space that it occupies in Bangladesh. So in 2017, a year after the Refugee and Migratory Movements Research Unit had filed its case, the Bangladesh Supreme Court handed down a historic judgment, and in that judgment, it sort of directed the Bangladesh government to immediately release Rafiq from prison and hand him over to the entity that had filed the case, which would then work in cooperation with the UNHCR to arrange for Rafiq to be given accommodation in one of the refugee camps in Cox's Bazar, Bangladesh. Now, but what's particularly sort of interesting and important about this judgment is what the Bangladesh Supreme Court actually had to say about the 1951 Refugee Convention. So at this point, I'm quoting verbatim from the judgment. So the Supreme Court in its judgment goes on to say that the Refugee Convention in its entirety has become a part of customary international law, which is binding upon all the countries of the world, irrespective of whether a particular country has formally signed, acceded to, or ratified the convention or not. Now, I have several thoughts about the interpretation of this particular interpretation by the Supreme Court. Now, from a practical point of view, the judgment marks the continuation of the Supreme Court's ongoing tradition of coming to the aid of the Rohingya who were sentenced under the Foreigners Act of 1946. So for instance, we've had similar judgments handed down in 2013, then again in 2015, etc. But as you're all aware, Bangladesh hasn't really ratified the Refugee Convention. And in fact, anything, if you read anything that's addressed to an academic audience or even towards a general audience, usually that article or paper will invariably start with that standard line. Bangladesh hasn't ratified the Refugee Convention or its additional protocol. And I mean, the thing is, this statement is factually accurate. But the thing is, it doesn't mean that Bangladesh is devoid of a framework geared towards supporting nearly 1 million Rohingya refugees. Now, and in this judgment that we're talking about concerning Mohammed Rafiq, the Supreme Court basically took judicial notice of the fact that the Rohingya were being persecuted in Myanmar, which had basically caused hundreds and thousands of them to illegally enter Bangladesh to save themselves. And the Supreme Court then acknowledged that, Rafiq would likely suffer persecution and torture if and that his life would actually be at stake if he were to be pushed back to Myanmar. So it's indeed interesting how the Supreme Court sort of justified its decision. It relied on, for instance, the fact that Bangladesh is a signatory to the Convention Against Torture, which sort of provides that state parties won't expel, return, or extradite a person to another state where there are substantial grounds for believing that he might be in danger of being subjected to torture. So the Supreme Court of Bangladesh then went on to consider the implication of the principle of non-refoulement in relation to Muhammad Rafiq. And it's at that point that it sweepingly held that the convention, the Refugee Convention in its entirety, had itself become a part of customary international law. Now, this is where I think things get a bit tricky. So, I mean, so to cut a long story short, the Bangladesh constitution doesn't really have any clear provisions explaining the status of customary international law within Bangladesh's legal order. And in the context of this absence, it's generally accepted that customary international law is binding as long as it doesn't really contradict domestic law. And I think it's really important to keep this context in mind when we think deeply about Bangladesh's judicial encounter with the 1951 Refugee Convention. On the one hand, Bangladesh hasn't really ratified the convention, and it doesn't really have national laws addressing refugee matters specifically. But on the other hand, Bangladesh is constitutionally mandated to respect international law and the principles of the UN Charter. So in light of the compelling argument that the principle of non-refoulement is now a rule of customary international law, it's not really surprising that the Supreme Court of Bangladesh followed it, adhered to it, given that there was an absence contradicting the principle of non-refoulement in domestic law. So as I sort of come towards the end of this presentation, I can't help but say that I conclude with a sense of having mixed feelings. So on the one hand, I mean, I feel really good about the fact that the Supreme Court is an institution that's situated far away from the 34 refugee camps in the southern tip of Bangladesh. And I'm kind of happy that the Supreme Court has sort of emerged as this entity that's potentially capable of upholding the rights of the Rohingya, empowering them, granting them protection. But on the other hand, I can't help but interpret the Supreme Court's sort of unadulterated acceptance of the Refugee Convention, as binding and with a sense of caution. I mean, the fact remains that despite having to directly engage with one of the world's largest protracted refugee situations, the bare reality is Bangladesh hasn't ratified the 1951 Refugee Convention. And and this is a question that we really need to sort of focus on. Why hasn't it? And unless we have an answer to this, I don't really think we have much of a choice but to treat this encounter, this Bangladesh's judicial encounter with the 1951 Refugee Convention with a little bit of caution. So that's pretty much all I have to say. Thank you.
Thank you so much. Without further ado, we turn to our next speaker, PhD candidate J. Ramasubramanyam of Carleton University, who will present his paper on ad hoc protection norms, India's antidote to the Eurocentrism of the 1951 Convention. The floor is yours, Jay.
Thank you very much for this opportunity. Sanjeeb, fantastic presentation. So it provides a really convenient jumping point for me to sort of continue with these discussions on how India's encounter with the 1951 Convention has also been equally tenuous and contentious. So thank you very much for that. The conventional history of the development of international refugee law sort of focuses on the European landscape. So what I'm trying to sort of examine in this discussion in the next 10 minutes is to quickly outline why India hasn't signed on to the Refugee Convention or ratified the convention or protocol, but also to explain that it hasn't in any way defied some of the objectives of international refugee law. So the core objectives of international refugee law have been maintained by India, which is what I mean by the antidote. So India's initial encounter with the Refugee Convention began with its disastrous end to colonization at least what I would say is the formal end to colonialism, which created arbitrary borders between India and Pakistan. And that resulted in India and Pakistan calling the attention of the international community to the ongoing crisis in the region. So both countries did arrive at the United Nations to establish a legally binding refugee protection framework. However, the language that was used to characterize refugeehood created an imperative that all forms of forced migration or forced displacement warranted similar policy provisions, irrespective of regional specificities. And this was evident from some of the moments of concern that was raised by India, specifically during the formalization process of the convention. Though India had agreed that the international legal protection norms remained the cornerstone of the refugee regime, they differed on the core principles of how it would be conceptualized. So India's commitment to refugee protection far predated the establishment of the 1951 convention. In fact, under the auspices of the League of Nations, India had provided sanctuary to scores of refugees from Europe, Russians and Armenians in the 1920s, and Polish, Greek, and many refugees from the Tsar in the 1930s. So India's forced migration practice grew out of responding to crises that were crippling Europe and not within the subcontinent. So it was a little bit of a surprise when India felt that their concerns were not being adequately captured within the core elements and core principles of the Refugee Convention. Having said that, the resistance showed by India to ratify the convention is not reflective of its practice. Until recently, and I say that until recently because I would get towards the end of it, it will become clearer why there is a lot left to be desired with respect to India's practice right now. Until recently, India has adhered to the overall objectives of international refugee law without explicit accession to refugee law instruments. So for instance, one of its first encounter with forced displacement right after the partition of India in 1947 was the arrival of Tibetan refugees. So in 1959, with the arrival of Dalai Lama, India had formally granted asylum to any Tibetan fleeing violence in the region. And this policy was initially in response to public opinion and a feeling of kinship, but subsequently was done in line with international norms. In fact, India had been so clear with its commitment to protecting refugees within the region that it created a central relief committee for Tibetan refugees under the auspices of the newly formed Indian government. And they had set up transit camps in the border states of India. They had then subsequently afforded permanent settlement to Tibetans in other parts of the country. However, there was still a lot of intervention, mostly from international parties, to say that India was incapable of protecting refugees without explicit accession to the International Refugee Convention. For instance, in 1959, there was an inter-office memorandum that was exchanged between the Commonwealth Office and the UNHCR that read that these refugees are living under miserable circumstances, and it appears that the directives given by the Indian government are not applied in a satisfactory way. However, India remained quite defiant in its approach and indicated that it will not seek the help of UNHCR in resettling these 12,000 odd Tibetan refugees who had arrived by the time. This continued with the arrival of Bangladeshi refugees. There were disturbances that were happening in East Pakistan that created massive refugee movements. This has become one of the cornerstones of India's refugee protection practice. By the time the Bangladesh Liberation War had begun in the 1970s, about 9.5 million people had already arrived at the Indian border. Finally, one of the things that I would like to talk about in a little more detail is constitutional provisions and some of the case law that creates the idea that India has contributed to refugee protection without explicitly signing on to the Refugee Convention. There were a couple of major Supreme Court cases that sought to clarify what India did in order to protect refugees. So one of the cases was Khudiram Chakma versus the state of Arunachal Pradesh. It was a petition filed by Chakma refugees, who were a group that had migrated from Bangladesh in the 1960s. The Supreme Court considered Article 14 of the Universal Declaration of Human Rights and Article 13 of the International Convention on Civil and Political Rights in holding that Chakma refugees who had escaped persecution in Bangladesh could not be forcibly sent back on account of the ongoing threats that they might face. And this decision was further affirmed in another case in National Human Rights Commission versus the state of Arunachal Pradesh. But some of these decisions are not confined just to the apex court of India. Some of the high courts in India have also extended protection and have also said that they are willing to work with the UNHCR in a symbiotic manner. For instance, there was a 33-year-old Burmese citizen who had fled to India to seek protection. And when she was apprehended for violating the Foreigners Act of 1946 and sentenced to 180 days in prison, she sought relief from the High Court of Guwahati in the northeastern part of India on the grounds that she had arrived in India due to fear of persecution. The court said that she can be granted relief from deportation so that she can approach the UNHCR in New Delhi to seek asylum. There are several other cases that have done very similar things, have made sure that refugees are not detained or deported on the grounds that they had a genuine fear of persecution upon being returned to their countries of origin. One of the comments that was made at the beginning of this conference was about the Global Compact of Refugees. Now, India was one of the contributors to the text of the Global Compact. However, a lot of it is focused on signatory states, and it's more or less pretty inconsequential to what India has done in the past. Having said that, the current regime in India has remained pretty uninviting and has also created a very ambiguous environment for refugees. So though India has been generous in the past by hosting refugees, in the recent years, there has been a change in tone. In August 2017, for instance, the government of India had directed authorities to identify illegal immigrants, including Rohingya refugees, and commence deportation procedures. Now, a writ petition was filed in the Supreme Court of India to prevent the forced return of many of these refugees, most of whom were Rohingya. Almost 4 years later, on April 8th, 2021, barely a couple months ago, the Supreme Court of India had issued an order rejecting the Rohingya refugees' right to non-refoulement. In rejecting the petitioner's plea, the court ordered that since India is not a signatory to the UN Convention or the protocol, the principle of non-refoulement is inapplicable. And the court had referenced national security ramifications and considered the arrival of refugees a threat to the influx of illegal immigrants. However, this has not remained the trend. Some of the judicial institutions at a local level have been defiant to what the government is focusing on. For instance, most recently, in May 2021, a decision in the Manipur High Court said that the far-reaching and myriad protections afforded by Article 21 of the Indian Constitution, as interpreted by our Supreme Court time and again, would indubitably encompass the right to non-refoulement. So, in summary, the task of rewriting the history of international refugee law by including perspectives from the subcontinent is a complex and ongoing process, as many of my colleagues would already know. Now, some of these responses have been strategic, They have been pretty ambiguous, but it is clear that there is a lot left to be desired in terms of understanding the Refugee Convention from a more holistic perspective, and hope that this narrative of exclusivity can be mitigated by more work and more policy changes. With that, I conclude. Thank you so much.
Thank you so much, Jay. And thank you to both Sanjeeb and Jay for keeping the time allotted to each your presentations. I would like to just remind our audience and our speakers about the possibility to ask questions and give comments in the Zoom chat box. So please keep that in mind. Our third speaker is Dr. Lysa of the University of Oslo, who will present her paper on the Rafha refugee camp and the establishment of Unhcr in Saudi Arabia. So Charlotte, the floor is yours.
Thank you so much, and thank you for that introduction. I am very happy for the opportunity to present my work in such an inspiring forum with so great co-panelists. What I will be presenting today is work I'm doing in another of project led by Professor Maja Janmyr, the Rafha project, focusing on refugee protection in non-signatory states of the Middle East. And in particular, I will share some thoughts on an understanding of Saudi Arabia and UNHCR as norm entrepreneurs that I will further develop together with Professor Janmyr in the following months. I will try and share some slides with you so that you can follow along. I think that was it. So Saudi Arabia hosts the world's second largest migrant community. More than 30% of the total population, over 10 million people, are migrants. And among them, many originate in countries where many refugees have fled, such as Syria. Only a few hundred, however, is registered as refugees by the UNHCR. Yet Saudi Arabia have continued to insist that it is hosting refugees, in the words of then Crown Prince Mohammed bin Nayef, and I quote, "not as refugees in camps, but on the basis of brotherly and ethical principles in order to maintain their dignity and safety." A non-party to the 1951 Convention relating to the status of refugees and the 1967 Protocol, Saudi Arabia is not bound by the Convention definition of refugees. There is no domestic asylum or refugee legislation, and while domestic laws such as the Basic Law of Governance of 1992 opens for applying for asylum, there are no formal regulations governing this process. Despite not having acceded to the Refugee Convention, Saudi Arabia is not disengaged in international refugee law. Already in the drafting process of the Refugee Convention, Saudi Arabia played an active part and was, together with Lebanon and Egypt, advocating for Palestinian refugees. So what role do international refugee law and UNHCR play in this context? And how does Saudi Arabia engage with the international refugee regime as a non-signatory state? So in the coming minutes, I will argue for an understanding of both Saudi Arabia and UNHCR as norm entrepreneurs, following Janmyr, who in the forthcoming article in the International Journal of Refugee Law shows both how the convention has influenced non-signatory states and how these states influence developments in international refugee law, and argue for examining the relationship between non-signatory states and the Refugee Convention closer. I suggest that despite not having acceded to the Refugee Convention or any other legally binding international instruments for refugee protection, Saudi Arabia is actively engaged in promoting its own understanding of refugee protection through established international channels, such as the UNHCR Executive Committee, while UNHCR uses its presence in Saudi Arabia to promote and spread the norms of the Refugee Convention. I will do this by first showing how the establishment of the Rafah refugee camp led to the establishment of the UNHCR office in Saudi Arabia in 1993. And I argue that the mutual engagement accelerated as a result of these developments. which made possible a stronger relationship between Saudi Arabia and the international refugee regime via UNHCR. Finally, I provide some examples of how both parties seek to execute their influence and impact the guiding norms of domestic and international refugee protection. In her memoirs, then UN High Commissioner for Refugees, Sadako Ogata, recounts the Gulf War of 1991 as, and I quote, a major watershed in the development of multilateral diplomacy and humanitarian action that set the stage for the post-Cold War period of the 1990s. More than 5 million people were forcibly displaced following the war and the brutal oppression of the Iraqi risings that followed. Among them, more than 30,000 Iraqi refugees who sought protection by the coalition forces close to the Saudi border in South Iraq. On April 9, the High Commissioner deployed a mission with a mandate to meet with parties and formulate recommendations with regard to these refugees. Saudi Arabia offered temporary asylum in 2 newly built camps, the Rafha refugee camp, hosting civilians and families, and the Al-Arqliya camp for those initially designated as prisoners of war. Both groups were consolidated in the Rafha camp in November '92. Now, the situation was extraordinary, and it included airlifting a number of refugees from Iraqi territory into Saudi Arabia. The majority of the refugees were resettled to third countries in the following years, and the Rafah camp shut down in 2009 after the UNHCR negotiated a deal with the Saudi authorities for the first time authorizing the settlement of about 300 of the refugees in urban areas, providing them with refugee identification cards, access to health care and education, and allowing them to work. Saudi Arabia had no established procedure or prior experience with handling such a situation, while the UNHCR had in practice no prior presence and exceptionally limited information upon making this first mission. The window of opportunity this situation provided was noted by the UNHCR, who during the mission discussed the opportunities for strengthening links with the Gulf Cooperation Council in light of the current situation. Nicholas Morris, who had led the mission, noted in his final report on April 26th, and I quote, "The situation now lends itself to the establishment of a presence in Saudi Arabia that could have a significance for UNHCR beyond the immediate reason for the presence. Just as the Gulf War, in Sadako Ogata's word, was a watershed for humanitarian action, the Rafah situation was a watershed in the relationship between Saudi Arabia and the international refugee regime through the establishment of a permanent regional UNHCR office. The establishment of the UNHCR office represented a new point of contact and have increased the engagement of both UNHCR in Saudi Arabia and Saudi Arabia towards the international refugee regime. The same year, UNHCR and Saudi Arabia signed a memorandum of understanding, which UNHCR still operates under, though some modifications have been made. The UNHCR has very limited access to actually assisting refugees within Saudi Arabia's border, but this does not mean that the office is simply a fundraising office. According to a 2005 report, for example, by the UNHCR, the strategic objectives of the regional office was to encourage adherence to refugee law principles, and the report stated that efforts have led to an increasing understanding of international protection principles. So among the activities of the office in this respect is a conference co-organized with the local university on refugee law and the role of UNHCR in 2002. This cooperation was later formalized, and starting in 2003, UNHCR have carried out educational activities in cooperation with NAIF, Arab University for Security Studies in Riyadh, with Saudi ministers participating in events. Now, Saudi Arabia, on its part, has often participated in the UNHCR's executive committee as an observer state. At a meeting in 1995, for example, the representative from Saudi Arabia responded to allegations by Iraq of poor treatment of the refugees in Rafah by pointing to the strong relationship between UNHCR and Saudi Arabia and stating, among other things, that, and I quote, all refugees benefited from full rights, including the right of protection against forced return. Now, in his speech to the Executive Committee in 2018, after highlighting the Saudi financial contributions to refugee situations around the globe, the representative from Saudi Arabia stated that Saudi Arabia hosts a large number of refugees as visitors, and I quote, these visitors do not live in camps in the kingdom, as is the case in many countries. Instead, they have the right to stay in the country where they receive free education and healthcare services and access to employment opportunities, the same privileges as enjoyed by Saudi citizens. In conclusion, the current engagement by UNHCR and Saudi Arabia, both acting as norm entrepreneurs seeking to promote an understanding of refugee protection, highlights the importance of including the impact by and impact on non-signatory states when evaluating the role of the Refugee Convention and international protection instruments. In the case of Saudi Arabia, while insisting on following a different set of principles based in Islamic law, the engagement in channels such as the UNHCR Executive Committee shows how the international refugee regime is considered relevant by the political elite, and how Saudi Arabia seeks to promote its own understanding. As a non-signatory state, Saudi Arabia is not only impacted by the norms of the Refugee Convention, but also seeks to impact. This relationship was strengthened through the establishment of the UNHCR office in the window of opportunity created by the situation of the Rafah refugee camp. I think I'll conclude there, and thank you very much.
Thank you so much, Charlotte, for that very interesting presentation. Our last speaker today is Dr. Jinan Bastaki of UAE University, who will present her paper on 1 Foot In, the relationship between the refugee regime and the UAE and Kuwait as non-signatory states. So staying in the Middle East, we hand over the mic to Dr. Jinan Bastaki.
Thank you so much, Dr. Maja, and thank you also to my co-panelists. All of the presentations were very interesting. I'm going to also share my screen and the slides. Here we go. So yes, so my presentation is going to be about how the UAE and Kuwait, in a sense, they have this 1 foot in relationship with the global refugee regime, and of course, 1 step out, in which, in a sense, they keep a distance from the refugee regime, and in a sense, avoid to be bound by the Refugee Convention itself, or even, we're going to see now, by the non-binding instruments. So this is the order that my presentation is going to take, and hopefully I'll stick to the 10 minutes. And so firstly, just as a background, the UAE and Kuwait, like Saudi Arabia, like Dr. Charlotte had said, they're not party to the 1951 convention. However, just because they're not in the 1951 convention doesn't mean that they don't engage with the global refugee regime. They do engage with it in different ways, and we're going to talk about those different ways further in the presentation. However, this 1 foot in approach, where there is a type of engagement, a voluntary engagement, in a sense, ensures that they can contribute to the support of refugees, they can engage with the UNHCR, and at the same time, without being legally bound to the international legal regime regarding refugees. And this, in a sense, allows them the flexibility to deal with the different situations that come up as they see fit. So before talking about each state, the United Arab Emirates and Kuwait, I wanted to just briefly look at the obligations of non-signatory states, because this is going to become important when you look at the role of the UNHCR and also how this one, foot in plays out. So we have obviously, like all the previous co-panelists said, the principle of non-refoulement, and this is obviously something that is it's very important in a country that doesn't have refugee status determination. And so this is also where the UNHCR's role becomes very important in, identifying who should not be returned to their home country. We have the principle of non-discrimination, the applicable provisions of human rights treaties, in particular with regards to the UAE and Kuwait. You have the Convention Against Torture, the Convention on the Elimination of Racial Discrimination, as well as the Convention on the Rights of the Child. Now, you also have this very interesting and peculiar, domestic law or constitutional provision, Article 46 of the Kuwaiti Constitution, Article 38 of the UAE Constitution, which says that a political refugee cannot be extradited. However, this law, just based on my research, has not been elaborated on in either state. There's no definition of who a political refugee is, how this political refugee can avoid being extradited, but nevertheless, the law itself is still there in the Constitution. And so what is now the context of the UAE and Kuwait? And so both are made up of very large expatriate populations. Charlotte previously said that in Saudi Arabia, it's 30% expatriates. In the UAE, it's over 85%. This is a conservative estimate. And in Kuwait, it's almost 70%. And both countries are considered high income, very wealthy. And naturalization in general is very difficult. In these countries, there is, in general, citizenship is really based very much on kin and tribe and how long you've been there in the country, and so naturalization is very difficult. Now here's where we find some differences, and this also explains perhaps the differences in their relationship with the refugee regime. So the UAE, it seeks to attract foreign talent. It's eased restrictive labor policies, and so there's in a sense a bit more openness to receive non-nationals. And there's also recently a change, an amendment to the citizenship law that also allows certain categories of persons who contribute to society to be given UAE citizenship. And actually very recently, a famous Syrian actor was given UAE citizenship. Again, this is not in the context of any refugees, but you can see that perhaps some people can be included for certain reasons. Now, Kuwait, on the other hand, there's frequently, if you read, the news in Kuwait, both in English and in Arabic, there's always discussions in parliament about there's too many non-nationals, there are too many foreigners, and we cannot let one demographic get too large. And there's always talk of, okay, it's 70%, we need to make sure that non-nationals don't exceed 30%. And Kuwait also has its own issues with its stateless persons. Badoon just means without. It's short for Badoon Jinsiyya, without citizenship. And some Badoon have actually sought refuge in other countries because of a clampdown on their political activity seeking rights. So this is kind of the general context of these countries. Now, what is this one foot in that they have in the refugee regime? So one is kind of, in a sense, it's monetary. It's not really with the mechanisms of the refugee regime, but rather this support for the UNHCR itself, as well as for refugee populations in host countries. So the Gulf states, they've mobilized significant funds for the support of refugees outside their territory. The UAE itself, it actually administers a camp in Jordan. And it's considered, relative to the other camps, one that is in very good condition. They have their own hospital within the camp, and the facilities are viewed to be somewhat superior. There was a joke when I was in Jordan that, this is considered a 5-star camp. And they support, obviously, efforts in Lebanon, Jordan, and the Unhcr more broadly. Kuwait has been one of the biggest supporters of Syrian refugees outside the territory, and they hosted a series of conferences in order to get pledges, and they've also been one of the highest donors. But as we know, these states themselves have not actually hosted refugees as refugees. Now, the UAE, they've highlighted that they have actually accepted Syrians, similar to Saudi Arabia, but they have not labeled them refugees. And there is evidence that the numbers of, Syrian refugees has increased. We have one number that the number increased to 200, around 50,000. And just anecdotally, I'm here in the UAE, and you can see more Syrians working in certain jobs. And according to the UNHCR, the UAE has largely abided by the principle of non-refoulement. The UNHCR, it registers asylum seekers. The vast majority right now are Syrian, but there are some numbers of Iraqis and Somalis as well. And they train government entities to recognize refugees and to refrain from deporting them. And sometimes if there's an issue at the airport, the asylum seeker can call the UNHCR, and the UNHCR seeks to get involved. But it's this training that, in a sense, advocates for the respect of refugee principles, and particularly non-refoulement. And those who have, valid residence permits, they're eligible for aid, from charities. And because of the improvement of certain labor laws, they can switch between jobs. So if somebody loses their job, they don't necessarily lose their residency straight away. Now, in Kuwait, the immigration policies actually remain strict. So in the UAE, they actually they were for a period of time very open to Syrian refugees, but they kind of it fluctuated. Sometimes they would close to Syrians, and sometimes they would open to Syrians. Whereas Kuwaiti immigration policy remained strict, and refugees are only allowed this temporary stay. And while the UNHCR operates in Kuwait, they don't have as much influence. And so in order for a refugee to stay, the UNHCR has to request a permit for the refugees to remain. This permit is temporary until the refugee can be resettled. While the authorities, they've generally refrained from deporting asylum seekers, and Syrians and Yemenis who have been on a deportation list, they were pardoned by the Interior Ministry. There's a law that no exceptions to deportations, that there can be no exceptions to deportations ruled by a court of law. And in 2018, there were reports of planned deportations of Syrians and Yemenis who had committed certain crimes. And so here, there was a huge discussion, and there wasn't actually ever really a follow-up, because there were, members of parliament who were critical of this move, but others were saying, well, this is the law, and they broke the law, and we cannot host them if they're going to break the laws of the country. So you have this kind of this uneasy kind of relationship. Now with the non-binding instruments, so we have the 2016 New York Declaration, the 2018 Global Compact on Refugees. In the first instance, there seems to be more engagement, right? So in 2016, the UAE announced very surprisingly that they would welcome 15,000 Syrian refugees, and they used the word refugees. And in 2018, the UAE created this temporary visa program in general, it was an amnesty for people who had overstayed their visa, but they created a specific category for those from war-torn countries, when this included Syria, Yemen, and Libya. And they could apply for that between August and December. And Kuwait also, at the 2016 summit, they announced that they would allow 3,000 Syrians into Kuwait in family reunification. However, with the Global Compact, now there was obviously great hopes in the Global Compact that allows, the states to engage perhaps in the refugee regime in a more involved way, but still in a sense on their own terms. So there's an expectation that perhaps there would be more of these initiatives. However, after, the adoption of the Global Compact, and both of these states adopted the Global Compact, if you look at their pledges as well as examples of best practices. So in Kuwait, again, 2 pledges, both financial, nothing to do with allowing, for example, refugees access to territory or anything like that. The UAE, on the other hand, again, or similarly, they also continued, to pledge to, support in financial ways. But even in terms of best practice, they didn't mention the visa program that they had. And it seems almost a distancing from this instrument, in a sense, for a fear that perhaps this instrument might be used to, in a sense, bring the UAE, more fully into the refugee regime, where they would be perhaps bound by certain laws. And so, like I was saying, so there is a shift from access to territory, like in the 2016 pledges, in favor of more monetary aid for the host states. And so what we can see is that even though there's this one foot in, there's an engagement with the UNHCR, there is this acceptance of the UNHCR operating and training and recognition of asylum seekers and enabling them to stay, there is still this resistance. And we can see it at least, perhaps more clearly with the GCR, and how, even though there were a number of initiatives, particularly in the UAE, that benefit refugees, that could be cited as examples of supportive refugees and access to third countries, they weren't mentioned at all. So it seems that now there's more of, one step out of the refugee regime. And I'm done with my presentation. Thank you very much.
Thank you so much, Jinan, for the fourth and final paper of today. Without further ado, I'll just hand over the microphone to Professor Dallal Stevens to make sense of everything that we've heard, I think. Draw it together somehow.
Thank you, Maja. And thanks very much to all the speakers. Thank you to Maja for inviting me to be a discussant on this panel. I'm very grateful, and I think it raises lots of really interesting issues. I see that there are already a number of questions in the chat. But I also just wanted to say that I think anybody who's attending here must be rebellious at heart, because you've chosen to attend a session in a conference dedicated to the 1951 convention, which obviously is dealing with states that are not party or not ratified. So well done. But that also raises a question, why are we discussing this in this panel? And of course, as Maja mentioned at the outset, examining the alternatives, particularly for those of us who are working in this area, is clearly very significant, because these countries we've been discussing are often hosting enormous numbers. But it also helps us to reflect on the possible issues, the challenges, potential flaws with the Refugee Convention. So there is a wider purpose, I suppose, behind this as well. So we've had a range of really wonderful papers today, and giving rise to a whole lot of themes and issues on which we can reflect, and I hope we can do so in the discussion. So I won't go on for too long, but there were certain themes that I think are worth mentioning as common themes, common features from what we heard from South Asia and obviously from the Gulf states. And one of the first ones, as we're all aware of course, is the resistance to ratification. So we heard that there is an ongoing resistance, even though that sometimes it does appear that there might be certain moves by states towards accepting some of the basic norms and the basic principles. And so Sanjeeb, we saw questioned about why is there ongoing resistance, and some of the other speakers spoke about the states that were enduring resistance and the reason for that. My own view is, as potentially has been mentioned in relation to comments of Chimney in the past, is that this is obviously an attempt at maintenance of control. And I think just the last speaker has shown that in the way that some states move towards greater involvement in some of the principles of the convention and then retreating. So it is definitely a maintenance of control. And we also saw that in Charlotte's paper, I think, on the UNHCR, and the way that states in these regions engage with the UNHCR. In a sense, they're more powerful in terms of their position in regard to the UNHCR if they are not party or have not ratified the convention. We saw mention, interestingly, of the principle of non-refoulement, which does seem clearly to be something that is largely adhered to. But again, we have concerns, and there are often a lot of cases that are conflicting. But there does seem an interesting move towards this under international law. Now, another thing that I think is very important for reflection is the role of domestic law as against versus international law, and which one is taking priority. Now, in these countries that we heard about and more broadly in the regions, a tendency towards domestic law being prioritized and their particular law on the foreigners. But this might be something where we see movement, and I'll come on a moment to some general questions where I will address this particular point to the speakers. But certainly that role of the domestic leads us in, as we saw in India and in Bangladesh, about whether the role of the courts is growing. So again, in terms of international law issues, but I think Jay hesitated a little bit to say that it had been universally upheld in terms of the courts in India, but we are seeing some interesting movement there, and that might be something that for practitioners and for those of us commenting in this area, that is where we need to address our concern. We've also seen in the papers the general point in the regions of the concern with the labeling or the use of terminology, and less so in South Asia, it would seem to me, but has certainly been prevalent in the Arab countries. So Arab countries have had a tendency not to refer or not to utilize the term refugees, with a concern that is maintained for Palestinians, but we heard also that in relation to Syrians, certainly in the UAE, they did use the term refugees, and we see this in other countries such as Jordan. So a slight movement away from the historic position to see everybody coming in as either guests or visitors. But what is also coming through is the adherence to the notion of temporality. So temporary asylum in the case of Saudi Arabia, but certainly also many of these countries wanting to return individuals as soon as possible. And if they're not able to, some sort of a rhetoric or justification to the host population that this is only a temporary form of stay. So that leads us on to think about what are the rights? Is it human rights law? Is it more broadly rights law rather than the convention rights that we need to utilize in order to fill the gap of not being a party to the Refugee Convention? And we see some sign of this in the discussions we've had, but of course also highlighted concerns. So I'm just going to pose 3 questions, which I throw open to all the panelists. They can answer some of them if they wish to, or one or more. And the first one was about why the ongoing resistance, which sometimes we feel if we're working in this area that we have to answer. But I want to raise the question, should we carry on posing this question? Is there any point in raising this if we know to some extent it is about control, it's potentially about influencing the UNHCR? So is there any purpose in discussing that? And if we choose not to do that, should our focus then be turned away from this, if you like, undue focus on the Refugee Convention to really thinking about the rights of the individual? So in a sense, coming up from the ground up, focusing on the individual and their rights rather than the over-focus maybe that international refugee lawyers have with the convention and its concern going downwards, if you like. And if we feel that, then the question becomes about how do we effectively implement and enforce those rights? So rather than focusing on the Refugee Convention, we really put our efforts into enforcement of rights, of human rights, of the individuals. And then the third question, if we do accept this proposal I'm putting forward about avoiding the Refugee Convention or getting too entrenched in discussions about that, it's no longer, if you like, about the Refugee Convention, but in a sense about international law principles. So we saw a little bit of that, the use of customary international law, the adherence to non-refoulement. Then what are possible implications of that? So can we reinforce it? Do we think there are going to be problems, for example, in Bangladesh, in India, or in some of the Arab states? Is it about the increasing role of the courts then? And do we then seek to influence domestic law rather than a push towards ratification of the Refugee Convention to ensure that whatever rights that we feel are important are accepted into domestic law. And that, in a sense, we can end on this point. If we do follow this line of thought, then what rights, which rights do we feel are absolutely paramount for those seeking some sort of safety in protection in these countries? So thank you for that. I'll just throw those open. Don't feel that you have to answer them, but just some thoughts that I felt were raised by the papers. Thank you.
Thank you so much, Dallal, for those thought-provoking questions and comments. We will open the floor now for questions and comments. I will give 4 minutes to each speaker to attend to any questions that have been raised in the Zoom chat, as well as respond to each other's papers and to the comments that came from Dallal. So we will start with you, Sanjeeb, and please stick to 4 minutes.
One from Alifa Haq and another from my dear friend and colleague Bazad Joarda. So the first question was, since the 2017 influx, with particular reference to the Rohingya refugee situation, how has the Foreigners Act 1946 been applied? Well, we don't have a great amount of data to actually be able to fully answer this question. But if you keep track of newspaper reports, it is true that Rohingya refugees on occasion are still being detained and punished under the Foreigners Act of 1946, irrespective of whether, let's say, they are categorized as forcibly displaced Myanmar nationals in the context of the 2017 influx. So to answer that question, it is still being applied. I would say that it would be good if it weren't applied, because there are provisions within the Foreigners Act of 1946 which allows the government to create exceptions, and the Rohingya in Bangladesh, in my view, should fall within that exception, and that law should not be applied to them, given the situation that they are in. My second question, the second question relates to the Supreme Court's decision on the application and the status of customary international law in the absence of ratification. Bazad is asking whether if it's fair to say that, will the convention become directly applicable to Bangladesh? And he opines that this direct application may be unconstitutional. From a constitutional point of view, I would tilt towards agreeing with Bazad. I do feel that given the positivist dualist tradition that Bangladesh has followed till date, the direct application of the entirety of the convention is problematic. But then, of course, that doesn't necessarily mean that norms of international refugee protection are inapplicable to Bangladesh, and that Bangladesh isn't caring about them. There's a long way to go. There are definite areas where improvements can be made and should be made. So it's only going up from here. But yes, so a range of norms would still nevertheless apply, even if the Refugee Convention does not directly apply to Bangladesh, simply because of a range of Bangladesh's pre-existing obligations under international law with regards to conventions that they already have signed, and also with regards to their own local laws and constitutional obligations. So that's pretty much what I have to say. I think I have 4 minutes. I think I've covered the 4 minutes. Thank you.
Thank you so much. Jay, will you take the microphone?
Thank you. I'm just going to quickly respond to a couple of questions from my dear colleague Nick Maple and from Ruben Wissing, and also a quick comment, a quick response to the comment presented by Aman. Nick, to answer your question, India's involvement with shaping the GCR was not particularly enthusiastic, but India did feel as though it was a shift from sort of a business as usual approach. It also is an active member of the executive committee of the Unhcr, and it felt that by participating in some of the proceedings of the GCR, there would be some level of legitimacy created to India's past practice. In addition to that, there were a couple of concerns that India had raised, which were both somewhat satisfied by the GCR's approach. One was the bulk of refugees that are being hosted continue to be in the global south, and there was a recognition of that in the GCR. And the second one was GCR's sort of approach to a universal perspective of refugee protection. So it is still anchored very, very much within the UN system, but India's response to that is still that it's relatively inconsequential because it's not a signatory to the convention and the protocol, and has been relatively open and dynamic in response to refugee arrivals in India. So it's still a very much a tenuous and contentious relationship with the GCR, but it was just to create a sense that India is an active participant in the refugee regime and would like to continue to create that sense of legitimacy in an overall level. In response to your question, Ruben, I cannot comment on that specific claim with the Belgian asylum procedure, but I can say that there are issues with respect to Tibetans in India. There are limitations in terms of their access, but it must also be said that since the probably mid-1960s, the Tibetan diaspora has been relatively settled in small towns outside of city centers, and they have their own economic and social system. They're relatively a self-sustaining system. Yes, there are issues with regards to access to jobs and access to employment, but which means that the population of Tibetans is slowly dwindling in India. But I cannot comment specifically on how that claim is being assessed in Belgium, because I haven't personally heard of refoulement of Tibetans, but I will certainly look into that because I may have overlooked something, but thank you for pointing that out. Aman, thank you so much for that comment. I really appreciate that. Yes, you know, what I presented today in 10 minutes is a very, very, very small part of a much larger work that I recently completed. There is definitely a strategic ambiguity in terms of hosting a lot of refugees, and that tone has obviously changed since the 1990s after the assassination of Rajiv Gandhi. So definitely there has been a steady decline in sort of an open-minded approach to refugee protection in India. But that's not to say that judicial institutions have not stepped in to try and mitigate some of those concerns. So I think there is something to be said about that. I'll try to quickly address some of the concerns raised by Dallal. Thank you so much for those comments. I think the focus for me personally is that, you know, it's a move away from some of the conventional frameworks and principles and more about practice. So my contention is that the focus should be more on practice of refugee protection as opposed to how we can implement or establish frameworks, which is why I think the role of judicial institutions are particularly critical with respect to India. And there have been moments of resistance that continues to sort of allude to not signing on to the convention, but working symbiotically with international institutions like Unhcr. But, you know, I can have, you know, we can have more discussions on that for sure. But thank you so much for this question. So I will leave it at that.
Thank you so much, Jay. Charlotte, some final words?
Thank you, Maja, and thank you, Dallal, for very interesting reflections as well, and Sanjeeb and Jay as well for adding some reflections. Briefly to comment on what you brought up, Dallal, on if we should ask the question of why not party to the Refugee Convention. I actually had this conversation with Sanjeeb just a couple of days ago, so I think it's a good question to ask. And I just think that regardless if that's the question we want to answer or not, what we're doing here now, kind of starting in the different end of the question and looking more thoroughly at what is actually happening and what is actually there, is a good starting point also for understanding more about the relationship to the international law and the role of the convention, and also ultimately questions regarding accession. There's a few questions in the chat as well that goes to both me and Jinan on the Gulf, and I think I should just briefly read them. The first is the Gulf states are important donor states to UNHCR. In what way, if any, does this fact have the potential of affecting the direction of UNHCR's provision of international protection and our understanding of this protection? I think that's a very, very good question. And unfortunately, there wasn't a lot of time to talk about this, but they are big donor states. That the UNHCR office in Saudi Arabia is fully funded by Saudi Arabia. And definitely on one hand, they do, the large contributions is awfully earmarked. So they do have some very direct effect. I think the other part, if Jinan might want to answer, but it's definitely something that needs to be looked into. And I know some people are doing that as well. And then the second question is, it seems that there's often a sense that satisfactory refugee protection can only occur if a state has acceded to the Refugee Convention and Protocol. Are there unique advantages to this GCC approach of bringing together elements of international law, domestic law, and cultural and religious norms to create an alternative protection framework? If institutionalized and strengthened, could this approach serve as a robust framework in its own right, or do you view accession as necessary for refugees' full rights to be ensured in the Gulf? Well, perhaps that's some of the questions we can aim to answer later in my work, at least. But I think to kind of flip it upside down, I think these questions regarding temporality and changing the focus from perhaps like more fundamental rights is going on all over the world, and understanding what has been happening in the Gulf for a long, long time will also provide some very useful foundations for discussing these questions, not only in the context of the Gulf, but also in a wider global context. And I think the starting point for that is to start looking at the Gulf countries as exceptional and actually pay attention to what is going on and understand what kind of protection, if any, is provided to refugees, including those who have stayed since around 1950, Palestinians, Rohingyas, and so on. And also the effect that these kind of temporary provisions have on them. And when doing this, I think it's really important to remember that these are very much ad hoc arrangements, even though if they have become permanent, more or less in some cases, and that this is not comparable to a more universal foundation based on universal rights and law. So that's just not an answer to any of the questions, but some initial thoughts, and I hope we can all continue this conversation further in the future.
So much, Charlotte. Before we close the panel session today, I'll just give the word to Jinan for a few minutes before I say a few words of goodbye.
Well, thank you very much, Maja, and thank you also to the previous co-panelists for the comments, and Dallal as well. So I'll answer the two questions that were posed to me and Charlotte as well. So in terms of the first question with regards to, does it affect, the UNHCR's work in terms of the funding and the donations? Like Charlotte, I'm not sure on this something it should be explored, but what I can say is that it definitely affects perhaps the UNHCR's, potential activism, because the UNHCR knows that, at least in the UAE is a major funder. The UN stockpile, the UNHCR stockpile in the humanitarian city is the largest stockpile actually in the world, and it's given by the government for free. And anytime there's a humanitarian crisis, at times also the government sponsors the transport of the humanitarian aid to where it's needed. So there's definitely this kind of this delicate dance around how much can advocacy for the 1951 convention or for the principles of the 1951 convention really be pushed. So I would say, like, as I said, I'm not sure about the direction of the UNHCR's provision of international protection. From what I've seen in my contacts with the UNHCR here in the UAE, it seems that they are doing their job as they usually do. The numbers are increasing because, as we know, the war in Syria and so on and so forth. And it doesn't appear, again, I haven't studied this, but this is just brief comments based on just some work that I've done with the UNHCR. It doesn't seem to have affected that. However, it definitely means that the UNHCR has to be careful perhaps in how much it wants to push for signing the 1951 convention, or even just respecting perhaps broader refugee law principles. In terms of the second question about the GCC approach, I mean, the GCC approach is not really an approach, and I think that, like Charlotte says, it's very ad hoc. Is it, like, just theoretically, is it necessary to accede to the 1951 convention to protect the rights of refugees? No, it's not. You can have your own domestic or even a regional provision that provides more protection for refugees than the 1951 convention does. And if it brings together cultural or religious norms and provides this protection for refugees, then of course I think that's something that can be welcome. However, it's what do we have now, and what we have now are very ad hoc measures, and like Charlotte mentioned, like very temporary. And I cite a lot of times, the protection and the support of Kuwaiti refugees in 1990, 1991. And Kuwaiti refugees were very unique because it was truly a temporary situation, 7 months. And then the majority of the refugees, within that year returned. Some stayed, but the majority returned, and they were allowed access to government schools. They were allowed to work if they could, by virtue of being GCC citizens. They were, allowed to rent an apartments. They had support by their own government, as well as the government, the host government as well. And this was the case for Saudi Arabia as well as the UAE. So you have this one example where all of those points that you mentioned in your question, international law, domestic law, cultural and religious norms, all of these that created this alternative framework that provided very high standards for those refugees, but it was truly temporary and truly only for that group of refugees. And so I think, it's not really whether the Refugee Convention is the only way to get protection of refugees, but it's what is available now, and what can provide a more, institutional and, something that can be, expected, and not just kind of relying on an ad hoc measure, a temporary measure that at any point could perhaps be revoked. And I'll stop there. Thank you.
Thank you so much, Jinan. I will now draw this panel session to a close. It's been wonderfully engaging with you all, and we have lots of ideas for further research, I think, after this session. So thank you to all of our speakers for your presentations, and to the audience for your questions. And for those of you who are interested in non-signatory states, please follow the Beyond Project on Twitter at non_signatory. So thank you, stay tuned, and enjoy the rest of your conference.